There's a statement by this court that Mr. Zuma must face the charges in the indictment. It's very difficult to say that it's not appealable because it's only a statement. It's not a reason. It's a statement that's put in that he must face the charges as outlined in the indictment. And it goes further, because what would happen if the prosecutor wants to either add charges or remove charges? But this court has said he must face charges in the indictment. We say that the court went too far in doing that.
Did the judges overstep the mark? The NPA further argued that unlike the case against crime intelligence boss Richard Mhluli, where the Supreme Court of Appeal instructed the charges be reinstated, President Zuma's case was struck off the roll.
Once it's off the roll, it is spent. The only thing that happens next is the prosecution service has to decide, should he now be prosecuted again? It doesn't reinstate the previous decision. It's gone.
If the current indictment is somehow stale, all that needs to be done is that it needs to be reserved.
The NPA also argued that the court's judgment contravened the doctrine of separation of powers. It said there was no need for Mokotedi Mpshe to have a court decide whether the abuse of the prosecutorial system was so severe that the prosecution couldn't continue.
The Director of Public Prosecutions has a far greater power to prosecute or not to prosecute, or to allow a prosecution or to discontinue prosecution compared with a court.
Asked why the matter was not taken straight to the Constitutional Court, the NPA argued that the Supreme Court of Appeal was capable of considering constitutional matters. The DA says it will put up a fight for the president to face the charges. Judgment has been reserved. Mphse, SABC News.